I'm often asked, I know the other side of my family law case is a liar. She's a liar. She constantly lies. He hasn't told the truth from day one. I'm always asked about that. How do we ensure that they're going to lawfully disclose? What I usually recommend to the people, whether I'm mediating or whether it's one of my clients in litigation, what I tell them is give me as much information as you can. I can't do anything without the information. If you don't have the information, then we ask the other side to produce it when we're in mediation, because again, everybody has to produce it honestly. If we still don't believe that there's an honest production, then we can confront the person who we think is being dishonest and say, disclose right now, sign on to the bank account, let me see what's on the charge card. Let's do it right now in front of everybody so that we all know we're being truthful and honest with one another. If that's still not going to satisfy the person, then at the end of the mediation, when we're done, if we're ready to sign, but before we have a question about whether or not there's been an honest and truthful disclosure, we can force upon the parties that they're both going to agree. If they've been dishonest, then they lose that asset. Sometimes we could say you lose 100% of that asset instead of the 50% that you might have had to give. Sometimes we will say you not only get to lose that asset, but you have to pay attorney fees. If there's any disclosures that were not made during the course of the mediation, and therefore cause the parties to, the legal term we would use is detrimentally rely. I relied upon your disclosure. Your disclosure was false. Therefore, I shouldn't have to pay legal fees and going forward after what I was rightfully entitled to. So we do have ways to do it in mediation that we can get people through and hopefully settle the case.